5 seconds to go. Start. While expressing the aforesaid view, we are conscious that the powers conferred upon the High Court under Article 226 of the Constitution to issue to any person or authority, including in appropriate cases, any government directions, orders, or writs, including the 5 prerogative writs for the enforcement of any of the rights conferred by Part 3rd or for any other purpose, are very wide, and there is no express limitation on exercise of that power, but at the same time we cannot be oblivious of the rules of self-imposed restraint evolved by this court, which every high court is bound to keep in view while exercising power under Article 226 of the Constitution. It is true that the rule of exhaustion of alternative remedy is a rule of discretion and not one of compulsion, but it is difficult to fathom any reason why the High Court should entertain a petition filed under Article 226 of the Constitution and pass interim order ignoring the fact that the petitioner can avail effective alternative remedy by filing application, appeal, revision, etc. and the particular legislation contains a detailed mechanism for redressal of his grievance. It could thus be seen that this court has clearly held that the High Court will ordinarily not entertain a petition under Article 226 of the Constitution if an effective remedy is available to the aggrieved person. It has been held that this rule applies with greater rigor in matters involving recovery of taxes, cess, fees, other types of public money, and the dues of banks and other financial institutions. The court clearly observed that while dealing with the petitions involving challenge to the action taken for recovery of the public dues, etc., the High Court must keep in mind that the legislations enacted by Parliament and state legislatures for recovery of such dues are a code unto themselves, inasmuch as they not only contain comprehensive procedure for recovery of the dues but also envisage constitution of quasi-judicial bodies for redressal of the grievance of any aggrieved person. It has been held that though the powers of the High Court under Article 226 of the Constitution are of widest amplitude, still the courts cannot be oblivious of the rules of self-imposed restraint evolved by this court. The court further held that though the rule of exhaustion of alternative remedy is a rule of discretion and not one of compulsion, still it is difficult to fathom any reason why the High Court should entertain a petition filed under Article 226 of the Constitution. The view taken by this court has been followed in the case of Agarwal Tracom Private Limited versus Punjab National Bank and others. In the case of Authorized Officer, State Bank of Travancore and another versus Matthew Casey, this court was considering an appeal against an interim order passed by the High Court in a writ petition under Article 226 of the Constitution, staying further proceedings at the stage of Section 13(4) of the SARFAESI Act. After considering various judgments rendered by this court, the court observed thus: the writ petition ought not to have been entertained, and the interim order granted for the mere asking without assigning special reasons, and that too without even granting opportunity to the appellant to contest the maintainability of the writ petition, and failure to notice the subsequent developments in the interregnum. Stop.